All right. Hi, everyone. Thank you for being here virtually and in person. I appreciate it. We think today's topic is super important, and obviously you do too. So thank you. Like David said, so I'm Dana Santangelo. That's my bio. And I'm going to click again. And
I'm Marla Korkus. I work with Dana for the past 13 years at Germantown Title. And I am more comfortable at a closing table and up here as a public speaker, so I will be referring to my notes throughout the seminar. All right, so as we jump in, I quickly want to set the expectations for what you will walk away with today. By the end of the seminar, you should be able to spot the most common issues that can delay or derail a closing. You should be able to recognize early warning signs before you even take a listing or go under contract. And you'll be able to use simple and practical strategies to avoid last-minute surprises. And most importantly, you should understand when you should bring the title company in early so that we can help save your deal and not just show up to the closing table. The goal here is to help protect your clients, your time, and your commission.
okay. So I love this visual. Thank you, Marla. So why title issues surface after contract? So this is how we want you to start thinking about your transaction. So on the surface, everything is great. You're under contract, your timelines are set, everything seems to be moving as it should be. But what title is working through, sometimes even without you knowing, until title is distributed and you are alerted to these things, are all sorts of yucky things underneath. So we've got divorce, name changes, judgments, unresolved estate issues, outstanding ownership rights, child support, prior owner title, prior owner judgments and liens. Because these don't show up, a lot of this doesn't even show up on MLS, and some of it doesn't even show up on public records. A lot of this we're learning as we're talking to your buyer or your seller to discover these things. So I think the good thing to remember is that the transaction isn't just the property, it's the person attached to that property. And in some cases, a prior owner that was attached to that property. So we're going sometimes a couple levels deep to clear title, to convey that clear title to the borrower, to the buyer rather, which is what you've engaged us to do. So the earlier we start uncovering what's below the surface, the better off we are and the more control we have over these issues to address them. So the main takeaway here is just to be aware that there are things underneath the surface that we're going to get to. So if it seems like we're asking too many questions, we have too many questions. Please know these are the items, these are the issues that we're looking for and trying to, if not avoid, to resolve early and get out in front of.
All right, so what it all boils down to is simply communication and also reading that title commitment that pops in your inbox from the start to the end. Whether you have the buyer or the seller, it does matter. You should be asking the right questions early, and if you're not sure what questions to ask, you should always be reaching out to your title partner strategically when you need more information. The deals that go smoothly usually have one thing in common, and it's that the right questions were asked early. One of the most powerful questions that you can be asking your seller is there anything in your life, your finances, or the property history that can slow us down? And when you start thinking that way, you're no longer just listing a property or working with a buyer, you're pre-screening your deals and you're giving yourself a huge advantage to get to that closing table successfully. When you pre-screen your deals, you are flagging potential issues before you even come up against deadlines. You're assisting with gathering documents or court approvals that you might need right away. and you're also setting realistic expectations for both your buyer and your seller. And most importantly, you're preventing those last minute surprises that make people panic. It's not the problems that kill deals, because any title problem it usually has a resolution. It's when you find out about the problem. When title issues are discovered late, the consequences are very real. Closings get delayed, which sometimes has rate lock issues with the buyers, or even worse, the deals can get canceled. Your buyers can get frustrated and walk. Sellers can get defensive or overwhelmed. And as a realtor or agent, you potentially lose commissions that you've already mentally counted on, and possible liability issues, because when deals start to fall apart, people start asking questions such as who knew what and when, and that's not a position that any of us want to be in. And the best way to avoid all of this is catching the issues early. So for the rest of today, we are going to walk through the most common issues that we see, the red flags that you can spot early, and what you can do to stay ahead of this.
My personal favorite, and the one we see probably next to estates the most frequently, divorce. I'm sure everyone online and in this room has had a divorce situation, and they can range from very congenial to very contentious. So what do we want to look out for? So what we hear all the time is, my ex isn't on the deed. No problem. Wrong. Even a spouse that is not in title needs to be addressed. Another thing we hear a lot is, oh, I bought the house before I was married, then got married, now I'm getting divorced, so we're fine because it's my house and only my name is on the deed. Again, sadly, that is not true. Well, it may be true, but it does mean that we do have to address the spouse. In Pennsylvania, a spouse has legal or equitable rights, as we call them, even if they were never in title, even if it was bought prior to the marriage, and even if there was a prenup. That's another one we get. Oh, I have a prenup, everything's protected. Maybe, but not necessarily. So from a title perspective, we can't rely on these statements of who's in title and who, when you were married, and if there's a prenup. So we can only rely on legal documents, agreements, and if it's really bad, a court order. Hopefully we don't get to that point, but that does happen. So when a divorce isn't fully understood up front, we're chasing this information while we're under a ticking clock for closing. So what we would like to see listing agents primarily doing is asking questions up front. Are you divorced? Are you married, divorced, separated? Where are you in that divorce if there's a divorce? Is the divorce finalized? Is there a property settlement agreement? A property settlement agreement is gold in this situation, because a property settlement agreement, hopefully if it's executed and completed, is both parties, both spouses or soon to be ex-spouses have signed it, and it addresses specifically the property, how it's to be distributed, how much money a spouse is supposed to get, anywhere from zero to a lot of money sometimes, so that we know who we are including on the ALTA, who we are including in our deed preparation.
Question.
Yes.
So in Pennsylvania, isn't it, my understanding is that the person who's not, they're married, but they weren't on the original deed, the house was purchased prior to marriage, is only entitled to the appreciating, the difference between when they got married and how much the home is appreciated.
Yes, they are only an equitable owner, but that calculation is not something the title company is going to figure out. So that's why a property settlement agreement or a mutual agreement between the parties, in order to have them both sign off, is required. Because part of the issue is well, who's been paying the mortgage? Who's been paying all the bills? Who's been maintaining the property? Who's been paying the taxes? All of that can go into that calculation. So a title agent isn't going to say, okay, only been entitled for 2 years, the property's gone up, or you've only been married for 2 years, the value of the property is X, and we do a simple math calculation. So we need the parties to come to an agreement. And look, sometimes they don't come to an agreement, and that's a solution as well. Sometimes the agreement is one of the divorce attorneys is going to hold all the money in escrow until a property settlement agreement can be worked out. And that's a completely viable solution that we often, we often use that option. Because the property.
You can still go to closing then, in that situation?
Yes.
But nobody gets funds.
But right, so everybody has to agree that that is the solution and be okay with an escrow, including the spouse that's not on title. Yes.
So if somebody's looking to buy a house and they didn't go through the divorce yet, but they
Or
are
a buyer, right? Okay.
And he has all the money, it's his funds, blah, blah, to buy. It sounds like he should get something from the wife stating that on the new purchase, she has no equity or
Yes.
whatever it is, maybe that's not the right words, but I guess something like that, right?
So
Before they buy.
actually, I was just going to get to, you also have to consider divorce for a buyer. If a buyer is in the process of divorce, so technically they are still married, the spouse that they are in the process of getting divorced from could have equitable interest in the property that they are buying, which is a problem if we're insuring a lender. It's a little bit less of a problem if it's a cash buyer, but I don't want to get too in the weeds on that. So typically what we do is we would ask for the soon-to-be ex-spouse of our buyer to sign a spousal waiver. And that protects everybody, the buyer themselves. Because one of the issues that we're concerned from a title perspective in that scenario is funds that the buyer is using are those marital funds. And sometimes we get into a situation where we're having to source money, and it gets a little tricky, and there's information we're asking that people don't want to share with us, questions we don't even want to be asking, but a marital waiver is the best way to deal with that.
So on the seller side, the listing side, what should we, agent here on that side, do to make sure that this does go to settlement and that you don't go to settlement and you have the table, all of a sudden the wife shows up and says, oh, the lawyer, and then things get, what happened?
Yeah,
so what should they ask
so
for?
what we want you as agents, listing agents primarily, to start doing is asking if there's a divorce. Let's not find out about a divorce when I run my title search and I see a pending divorce action, and it's news to you and it's news to me.
Also, the divorce action might not even be in the county where the property is being sold. So a divorce can be missed totally if the seller isn't upfront about their marital
I
status.
think he's saying is if the buyer shows up,
Yeah.
if the buyer shows up going through a divorce, can that hold up settlement?
It
Yes.
will.
If there's not a
Right.
Right.
And to Marla's example, an issue that often occurs is they are involved in divorce. They might not have mentioned it or nobody asked, and we didn't find it on the title search because they filed in a different county.
You wouldn't find that for the buyer though, would you? If a buyer is good, if a buyer.
Buyer's pending divorce, if it was filed in that county where the property is, would show up.
Oh, you would,
Because we're
okay.
searching the buyer and the seller by name. So if they're a party to a divorce action, it will show up. But if our property is in Chester County and they were living in Montgomery and that's where they filed, we're not going to find that because it's a county-based system. So that's why
If we discover your buyer is going through a divorce, you need to dig a little further, is what you're saying.
Exactly.
Find out if they're
And that's
well,
when we want you to get the title company involved. Hey, my buyer's involved in a divorce action. We're not asking, we don't want the agents to kind of take lead on this. We just want you to know, to ask the right questions. That's kind of what this whole presentation is about, is asking the right questions when you're sitting with a buyer and a seller.
Yeah, so if they say, no, my spouse I don't have a waiver, I want to go through with this, but that could potentially delay.
Well, the waiver would be for a buyer, a spousal waiver, we would provide that.
Right, but if they were like, well, they refuse to sign it, or they haven't signed it, or they don't want to entertain that, I would say, well, then
Yeah,
maybe
potentially.
you're not the buyer I want to use, right? I mean,
That's when you want to bring in your title partner, especially if it's a buyer who, you should probably have a good relationship with that title company. You want to say to them, hey, I've got this buyer. I don't know if their soon-to-be ex is going to be agreeable to a waiver. What are our options? Let's have that conversation even before you go under contract. Separation is also can be risky. We've seen situations where, for one reason or another, people aren't, they're not living as a married couple anymore, but they're not actually divorced, and they're separated. That often requires a joinder. We've had to track down spouses that haven't been seen or heard from in years to sign off on a deed to release their marital interest because they are still married. So, are you are you married? Are you divorced? Are you separated? These are the questions. The sooner you ask them and the sooner you know the answers to them, the better prepared we can be. Yes.
In Pennsylvania, I'm not sure about this one. Is there a thing that if two people have lived together for X amount of years, that the partner, whatever they're splitting up?
Common law?
Yes.
Yes, no. Not from a title perspective.
So when you track, I had a situation in Philadelphia where it was weird that they checked the property address. So you have this person have known a few properties in Philadelphia, and there were some liens against the other properties, claimed that they were all taken care of. The property that I was selling was clean, title ran, clean title. Then they looked under the name and they said, well, wait a minute. This guy's got a lot of liens with the city of Philadelphia.
So we have another slide on liens and judgments, and we're going to get there. So maybe just remember that question in case I forget.
I have a question from the Zoom attendees, if I can relay this. Okay, this is from Connie. She says, I have a listing that is in the midst of a divorce. Couple has agreed that wife is entitled to marital home and any proceeds. They agreed to change the home fully into the wife's name. Will they need a settlement agreement at that point? Can they do a settlement agreement prior to listing the home?
So now these get into some legal questions. So I just want to, our disclaimer, I'm not an attorney and I don't play one on TV. But from a title perspective, we would still want, ideally, a property settlement agreement or some kind of signed agreement stating that she gets all proceeds. And it could be something as simple as a split proceeds authorization. I get 0, she gets 100%, and the spouse that is not selling the property, signs off on our deed. All right, moving on.
All right, so recent marriages also ties into name changes, and I'm going to give you a real life example of a closing I had a few months ago. I was at the closing table, and it's pretty rare nowadays, but both the buyer and the sellers were present at the closing table. Everyone was ready to sign. I collected IDs, and lo and behold, I look at the seller wife's driver's license, and it does not match the name that she purchased the property on. So I asked her, did you recently get married or change your name? And she mentioned that she did get married. And in that moment, it became clear that despite the fact that I asked 2 or 3 times before the title is even circulated, if there are any name changes that we should be aware of, that information was just not passed on. And it's not a complicated title issue, but it is a breakdown in communication and a lot of assumptions. And from the seller's perspective, it's just a name change. It's not a big deal. Sometimes they don't understand why it matters in a transaction, so they don't always volunteer that information, which is why it's important for you to be asking these questions. So we're at the closing table, and I have to stop the transaction because now I have to run a search on the seller's new legal name. 4 judgments did pop up. And because the right questions weren't asked early, now we're dealing with this situation at the worst possible time. Title insurance is about proving on paper that the person signing today is the same person who took the title years ago. We can't just assume that they're the same person, even if everyone in the room knows it. Assumptions do not work in title insurance, documentation does. when someone gets married and changes their name, we have multiple layers that we have to look at, and the closing table is not the appropriate time to be doing that. If the name on title no longer matches their legal name, we have to answer 2 questions. Who is actually signing today, and are there any liens or judgments under the new name? And this is where things get missed, because judgments can be filed under a person's legal name at the time the judgment is entered. So if someone was Jane Doe when they bought the house and became Jane Smith later, any new judgments might be under Jane Smith, and we had only searched Jane Doe. If we don't know about the name change, we are not searching the right person. And again, that's not something that should be discovered at the closing table. At the closing table, people generally do not have quick access to the documentation that supports the name change, and fixing a problem in real time creates a long and uncomfortable closing while the solution is being created. Again, the fix is manageable, but it's not a last minute manageable fix. The seller.
So,
Oh, sorry.
Wife or husband, should they get married, well, you know, and she changes her name, should she get the name changed on the deed?
You can pay an attorney to do that, or a lot of people address that when they refinance, or if you sell the property. You can do it on the outgoing deed. We just need to be able to list the pertinent information in the body of the deed, so the chain of title can be followed.
Again, a best practice is have you changed your name? You know, because you're going to go onto the MLS public records, you're going to see in this example Jane Doe, her pre-married name. When she's signing the agreement of sale, it'd be great if you could, oh yes, I got married, now I'm Jane Smith. Jane Doe, now known as Jane Smith on the agreement of sale, totally solves that, because that's what we get, and that's how we're going to write up our title search, or how we're going to order our title search, excuse me. And then both names are going to be searched. And God willing, it's really not Jane Doe or Jane Smith, because we're going to get a lot of hits for that.
In that example, were you able to close that day, or did you have to reschedule?
I had to escrow a lot of money, which did affect, they were buying a house immediately after, so that did affect the amount that they were bringing to the next table.
So essentially, nobody left happy, which is not the goal ever.
If they bring a marriage certificate, does that suffice?
Yes, but that should not be brought to the table. That should be given ideally when the title company introduces themselves as a party to the transaction. You should be emailing or calling a title agent with that sort of information.
So they had to pay extra money because they owed money to someone else that they...
We had to escrow. They got some of it back, but not all of it.
Because unfortunately, the new name she had for, I think were they credit card judgments, or?
Yeah, it was all mostly.
You had to take money and they had to pay that.
Yeah, exactly.
Right, okay.
Yeah, because she owed it. It was money she owed. We just didn't know about it because we didn't search the correct name.
Right.
Is there a certain amount you should have, is it 2 times the amount that's owed or 3 times in escrow? I've heard difference.
Usually it's, if there's any cloud on title or issue, minimum, it's usually 1.5 times the noted amount on the title commitment or the filed judgment or mortgage. All right.
So there's certain things where you could go a little less, certain things you might even want to go a little more, but the general rule of thumb is 1.5 times.
All right. So when the seller has a name change that we're dealing with, they need to produce a marriage certificate or a legal name change document. The deed also has to be corrected with the proper deed language, as Dana mentioned, also known as or formerly known as. Searches do have to be run on all of the names. And then if issues like judgments do pop up, payoffs have to be ordered. And most times payoffs are not quickly attainable. And that means funds will have to be escrowed at the closing table, and having to escrow funds is usually problematic if your seller was relying on a certain dollar amount to purchase another home. So your takeaway is what you should be asking your sellers early before you sign a listing contract or when you're signing an agreement for purchase is don't just assume you know what their name is. Ask what is the name on your ID. Ask them, is it the same name that you purchased the property and is showing on the deed? And have you ever changed your name?
All right, so this is a good segue into photo ID. Is it valid? Hopefully, yes. We need unexpired, government-issued photo ID at closing. At the closing table is not the time to learn that your buyer or seller doesn't have unexpired, government-issued photo ID. This is a great question, and it seems silly, and oh my God, all these questions, but do you have valid ID? And you might even want to ask to see it when you're writing up an agreement of sale. The other reason we mention this is, especially right now, seller impersonation fraud is on the rise. So I'm sure you've heard about that in other classrooms like this, but knowing your seller is a really good idea right now. As far as photo ID goes, we need it to match within reason. We know sometimes is the whole middle name spelled out? Is it just an initial? I mean, obviously we're not getting, too crazy, but the name on the ID needs to match the person who we're taking it from, who's going to be signing in that name. This again goes back to, have you changed your name? The only reason Marla noted that was when in her example she just gave, when she took the ID, it had a different name. So we really want to make sure the names that we are putting on our contracts are the names that are going on the title commitment, and all of the other future documents all have the same name. So simple questions to ask early. Again, do you have valid unexpired government issue photo ID, and does it match how you are signing? It's a very small detail, but it's something that we run into. So it was worth mentioning today. I'm sorry, did I see a hand? Did somebody have a question on photo ID?
Are you requiring real ID, or is it a point in time when you do?
No, we are not requiring real ID. I don't know that anybody is, but in our operation, we are not concerned about real ID. And government issue doesn't necessarily mean a driver's license. It could be a passport. It could be other sorts of government issued. I've taken military IDs. People like to hand me their gun registration cards. I don't know why that's a popular one, because it is government issued photo ID, so we see a lot of those. And also something of note is that some lenders do want two forms of ID. We try to catch that early for a buyer-borrower, so that we tell them in advance. Most people don't walk around with two forms of ID on them. So,
and usually the second form, it doesn't have to have a photo
Yes.
on it. It can be your birth certificate, voter registration, social security card, things like that. Like last resort, I'll take someone's health insurance card, whatever's in their wallet that's not a credit card. And just a quick sidebar is you don't want to put the title agent at the table in a scenario where you're suggesting just make it work, because a notary has a license and they have certain duties, and one of them is, according to state code, looking at the unexpired government issued ID. So if you're asking someone to kind of just, ignore the fact that it is expired, you're potentially putting that notary's job on the line, because notaries do get audited, and there's significant fines and jail time, and you can lose your license and that notary's out of a job.
Right. And then if they don't have a driver's license, but they have like a green card, is that what like legal immigrants use in some cases?
Yes.
Is that acceptable? I mean,
yes, as long as it's government issued photo ID.
And you can
And
always.
I believe they do have photos on them.
Yeah, I'm not that familiar with those, but
And then part of your job as a realtor might be putting your client in the car with all of their other government issued forms of ID, like a birth cert and social, and taking them to the DMV.
We've
So
had
at
that happen.
minimum, they can get a state ID as opposed to a driver's license.
what's that called?
What's that called? Just a state ID?
State ID. Mhm. Yeah, it looks like instead of Pennsylvania driver's license, it says Pennsylvania state ID.
For somebody that's incompetent, maybe that's not the right word, but so the POA should show up also at settlement with their ID?
Well, we get to
There's a slide for
POAs.
that. But yeah, you'll need, if someone's incompetent, number one, a notary wouldn't sign, accept their signature because you have to be of sound mind to appear before a notary public. But yes, there's a slew of items that we would require if someone let us know at the time the title is ordered that a power of attorney is going to be used. But we'll get into that shortly.
No, I think we're good on this one.
All right, so. All right, so death of an owner ties in being an heir, having an authority. It's usually one of the most emotional and misunderstood title issues that we see, and it's a good example of how title issues pop up from life events that were not documented, as opposed to like a judgment or a mortgage or something simple on a title that needs to be cleared. When you're talking to a family as a listing agent, it often sounds like they passed away years ago. We've been living in the house ever since, and from a title perspective, that's exactly where the problem begins. Death in title is an issue because when someone dies, ownership does not just automatically transfer because the family members agree that that's what should happen. Title insurance requires us to prove with legal documentation who has the authority to sell the property. And until that authority is clearly established, title just cannot insure the transaction. So the first question that you should ask or look into is regarding tenancy. That is, how was the property owned at the time of the death? And this answer determines everything that follows. And it's something that you can confirm by reviewing the deed that put the seller or the decedent in title. If they can't find that, that's when you call your title partner and ask them to order a copy of the deed from the courthouse so you can see what the deed says regarding tenancy. So we'll go over the forms of tenancy real quick. If the property was owned as joint tenants with rights of survivorship, the deceased owner's interest typically passes to the surviving owner, and that's an automatic process. The seller will still need to provide the death cert of the person who passed, and it's important to understand that inheritance tax does need to be addressed. Just because the surviving rights went on to the next property owner, there's still inheritance tax, and that's where we see a lot of confusion and misunderstanding. Many people assume that joint tenancy avoids inheritance tax, and it simply does not. It's not uncommon for sellers to be surprised and often frustrated when they learn that inheritance tax has to be handled or addressed through the closing. The next tenancy is tenants by...
And I will, if I can just interrupt. So the surviving tenant would pay the applicable rate on that 50%. So it's not on the whole value of the property, it's just on the decedent's 50% share.
All right, the next tenancy is for married couples. It's tenants by the entirety. It has a similar result to joint tenants, where the ownership passes to the surviving owner by operation of law. And the good thing when tenants by the entirety is noted on your client's deed, you don't have to worry about inheritance tax. You will have to provide the death cert, but that should be about it. The other two options for tenancy are sole ownership or tenants in common. And if there were no other owners or the property was owned as tenants in common, the deceased owner's interest becomes part of their estate and the property needs to be administered. If the tenancy isn't addressed correctly when you're obtaining your listing, the wrong person may believe they have the right to sell, and that can stop a transaction. A common misconception is that an heir automatically equals having the authority to sell the property, and it does not. A court-appointed executor or administrator is the only person who has the right to sign a deed, to sign your listing contract, and to sign the agreement of sale. Until the probate is opened and you have the appropriate documents, you should not be proceeding with any paperwork, even if all of the heirs say they agree. In Pennsylvania, when you're dealing with an estate, your seller is the person who is named on, it can go by 3 different names. It could be called the short certificate, it could be called the letters of administration, or the letters of testamentary. It all depends on if you died with or without a will and the title of that document. But that document is issued from the Register of Wills, and it confirms 3 things. It confirms that the estate has been opened, it confirms who has the authority to act, and it determines that the authority is still valid so that you can proceed with getting all of your documents signed. Without it, the person signing your contract does not have the legal right to convey the property. So it's a hard stop until you see those documents with your own eyeballs before you have signatures on your papers. The third matter you want to ask your seller when you're dealing with someone who is deceased is, what was their marital status at the time of their death? Title will want to see the death cert to confirm the marital status, and it's basically to ensure that they were not divorced or going through a divorce proceeding at the time of your death. And this is also even if a spouse or former spouse was not named on the deed. Surviving ex-spouse's right can affect ownership even years later or after the death. The last item to review with the sellers as early as possible is regarding inheritance tax. Inheritance tax is often a surprise for many sellers, and in Pennsylvania, inheritance tax is applied depending on the relationship of the heirs to the decedent, and that's all usually spelled out in the will, or if they died without a will, the court gets involved to establish who the heirs are.
So you must redo the will before you sell it, because somebody dies and the will says so-and-so's the executor. Do you have to?
Well, the original will, that's part of the probate process. Whoever is assumed as the executor or executrix has to make an appointment with the Register of Wills, and you're showing up with the original will, you're showing up with the death certificate, and maybe a few other forms, and that's all filed within the Register of Wills, and then that short certificate is issued conveying the authority.
So I would suggest asking for the short cert. It's a simple 1-page document, and it very clearly states who has the authority to sign any of the contracts, whether it's listing or agreement of sale that you're putting in front. And if they don't have it, again, that's when you might want to call your title partner and say, hey, I have this listing appointment. I don't have, what should I be asking for? What would you recommend?
So the short certificate is going to suffice to go to settlement, correct? With a will, identification, and what's the last one?
Yes, sir.
And the death certificate. Yeah, and that's all they need to go to Registry of Wills. I'm going through this right now.
To go to the, I would call the Register of Wills to verify. Well, first of all, you make an appointment usually.
No appointment.
You can just show up. Yeah, I mean, usually the Register of Wills for any county does detail on the website what is initially required to show up, but that's a good start, those 4 items.
Yeah, they told me that the 3 items, and that's it. And the title company said, I just need the short certificate. And that's it, right?
Well, typically we want to see the will as well, because the will is going to show who the beneficiaries are so that we know how much escrow, and in most cases we're escrowing for inheritance taxes. If the beneficiaries are a living spouse, then we don't have an issue. If the beneficiaries are children, it's a 4.5% rate. If they are not linear but lateral, so they're siblings, then they would be 12%, and then
anyone else,
friends, the neighbors
nephews,
are at 15%. So we want to see the will.
Calculates that?
Yes.
So title went regarding inheritance tax. title will require, first we ask, has the inheritance tax been paid? Most often it hasn't. Heirs usually rely on the funds from the sale of the property to pay the inheritance tax, so it's rare that we see that inheritance taxes have been addressed prior to closing, which is why we offer the ability to escrow the funds. So the amount that's escrowed is pretty standard across the title insurance industry as a whole. As Dana just mentioned, the applicable tax rates, the formula that every title agency uses is the sales price multiplied by the tax rate times 1.5. The 1.5 is not a percent, it's just 1.5, and we have to take into consideration that we don't know what the other assets in the estate are, or if the tax is being paid significantly late and penalties and interest are accruing, and the Department of Revenue does not mess around with adding on those interest and penalties, and it adds up very quickly.
So you escrow that?
We have to escrow it, and honestly, I don't know if you see it from a realtor perspective, but I have an insane amount of escrows that I'm holding pretty much since 2024. The only houses that we really see going on the market have to deal with someone dying or divorce. So that usually involves funds being escrowed.
Just a quick question. So husband and wife inherit a house from the husband's father. They don't pay inheritance tax at that point. Subsequently, the husband dies. Does that wife now have to pay the inheritance tax from the father plus her husband?
Well, not her husband, as long as
Depending on how they took title.
Right, depending on how they took title. But generally, married couples own it as husband and wife tenants by the entirety, so that avoids the inheritance
But the
tax.
fathers, the inheritance tax that was due that they didn't pay at the time the deed was changed, it does.
Yeah.
The state is very patient. They will wait for it, but they want to get it.
So inheritance tax is just what it says. If you inherit a property from someone, right, you didn't pay for it, you inherited it.
Yes.
Right, you're owed this tax. But if the homeowner just dies and now it's in an estate and they just put it on the market and sell it, and someone unrelated just buys it, there's no inheritance tax that's
There's
paid.
always inheritance
There still
tax.
is inheritance tax because the value of that home is going to be distributed to the beneficiaries of the will.
Well, no, I mean, what if they're not giving it to the beneficiaries, they're just selling it outright?
But that money is going to be,
The estate.
the proceeds of that sale are going to be payable to the estate, and the estate will make distributions to the beneficiaries
The
that,
estate has to pay the.
yes.
Okay, and did I hear you correctly, Marla, when you were saying earlier, it depends on how the deed is structured, that there may or may not be like inheritance tax that's due?
Yes. So if going back, if it's a spouse, if you own the property with your spouse, and you don't have to pay inheritance tax for the first spouse who passes. But eventually,
And then
when
second spouse.
then inheritance tax will be owed.
So it's just a matter of time. right?
Exactly. In Pennsylvania, it's just a matter of time.
And it's, okay. And is it only, you said it's only 50%?
Only.
Well, if you're joint tenants with the right of survivorship, so Marla and I own a property together, we're joint tenants with the right of survivorship. Something, I pass, she inherits my 50%, she will have to pay, well, in this example here, it would be 15% of the value of my half.
You're saying two people own a house for years, right? Husband and wife. The wife passes. The husband now has to pay an inheritance tax?
No, there's no inheritance tax between spouses.
And what's the formula again? You said for children, it would be 4.5% inheritance tax?
4.5%
So it's sale price
times the tax rate
times 4.5, right?
times.
Times 1.5.
And then
And-
there are, that can be reduced, but you have to have the paperwork to back it up. We have underwriting attorneys that we all work with closely, and they will reduce it. They'll be willing to reduce the risk on their end if they can see, number one, has the estate made any prepayments? If an estate makes a prepayment, the Department of Revenue issues a document called the official receipt. So if you can provide an official receipt showing X amount of dollars has been paid, along with a prepared, even if it's preliminary, a prepared inheritance tax return and the will. So that's where it is helpful, where you obtain the will. If you present those 3 documents to a title agency and say, hey, is there any consideration in reducing that formula that we just detailed? Most of the time we can reduce it from that large amount, but no matter what, even with that reduction, the math always equals out to a significant number. And if your seller is not mentally prepared for the fact that that significant number needs to be escrowed, you're just creating a frustrated client. So it's definitely something that you want to address as early as possible. Ideally, when you're doing your listing presentation, it's something that you should bring up, indicating that you're a knowledgeable agent and letting them know what to
And
expect.
something just as simple as, hey, there may be an escrow, money's collected for inheritance tax. Just want you to be prepared. I don't know what that number is yet. We're going to work with the title agent to figure that out, but just so you're not surprised, inheritance taxes will need to be addressed throughout this process.
So then, there's that 50% uplift, right? Like 1.5 multiplier on top of whatever's, they calculate to be owed. How long is that held on to?
So it is held on to until the estate can produce the document that clears the title. That document is called the Notice of Appraisement. The Notice of Appraisement is issued by the Pennsylvania Department of Revenue, and it's only issued after the inheritance tax return was filed with the Department of Revenue and the tax was paid according to what the return detailed. The state does an audit on the return, and they issue that document called the Notice of Appraisement, and it will say one of 3 things. It will say that no additional funds are owed and the return was accepted as filed. It can say that the estate owes more money, and it will include a calculation as to how they arrived at the additional funds that are owed. Or what we see less often is the estate is owed a credit because they paid too much in taxes.
So if they owe additional ones, that's things outside the real estate transaction.
Yeah, it's usually like stocks, bank accounts, any other asset that might have been listed or maybe produced or even found by the Department of Revenue.
So it's correct to say, like, once the estate is settled.
Exactly.
Yeah, exactly.
And then a lot of times we're using that escrow to actually make the payment, and that's okay too. Some estates, the only money they really have are the money that I collected. So, get me the return, I'll see the bottom line, I'll release that much of the escrow, and I hold on to and typically we have a balance because we've had that extra 50%. We hold on to just that remaining balance until the letter of appraisement is received. Because we want to know we are good to go. The state's happy, they've accepted the return is filed, and then all the monies that we have is returned. Or if there's a small balance, typically we'll pay that out of the remaining escrow and then release the balance.
I'm thinking like my client's thing. So they're going to say, well, how long is that? Are we talking?
It takes as long as it takes them to get it done.
It generally takes after the return is filed and the payment is made 6 to 9 months. It is not a quick process.
It is not.
Any other questions?
We could do a whole session on between divorce and estates. We could do a whole thing.
So for realtor, it sounds like they definitely should be sitting with an estate lawyer, go through all this stuff because they have stock, blah, blah, they're going to sell the house. Somebody's going to say, look, at the end of the day, this is what the inheritance tax is going to be roughly, just so they're not shocked,
Yes.
If they could have a house, they could have stocks, to your point. So they should sit with, we should say, look, you should sit with an estate lawyer, blah, blah. get it, 'cause we're not experts in that.
Right.
No,
Exactly.
and you're not accountants or lawyers.
And
so
our
you don't
and
wanna
our
be giving
smoothest estates, honestly, are the ones where there is an estate attorney involved. They know exactly what we need. They get it to us. They understand what we're asking for and why. They understand the escrow that we're holding, and those returns I typically get, because as soon as the house is sold, they're filing those returns. So those are the smoothest ones that we see.
All right,
move
so
on. I think
to
we're gonna get
summarize, when you're dealing with the death of an owner, delays or frustrations happen because probate was never open to begin with. The wrong person assumed authority and signed your listing contract or agreement of sale, or inheritance tax was overlooked or not addressed ahead of time. Your takeaway and questions for your future clients when you're dealing with death or estates, or a seller who inherited a property should be: who were the owners of the property, locate their death certificates, was probate open, who is the executor or administrator, and has inheritance tax been addressed? When you ask these questions early, inherited properties close smoothly.
All right, powers of attorney. I love this one. Not so fast. Powers of attorney are one of those things that sounds so simple. Oh, we'll just do a power of attorney. They are not that simple. Powers of attorney, quite honestly, for title companies are just a huge red flag. The problem with powers of attorney is a lot of times they're used as a quick fix, but it actually creates more problems and issues and questions than they solve. So I think the mindset shift here as an agent is not to think about a power of attorney as a quick fix, but actually something that is going to create additional work, additional communication. And look, there's plenty of situations where powers of attorney they're necessary, they're required, and we understand them. But from a title perspective, they are a big closing delay. I actually had a closing where somebody showed up with a power of attorney that they had not mentioned throughout the entire transaction. That is not when I want to learn about a power of attorney. I want to know about a power of attorney as soon as possible. If it comes over with the agreement of sale, that's actually the best time when you're sending your title order in. Hey, this seller is in a nursing home, in a hospital, out of the country, and we're going to use a power of attorney. The questions that a power of attorney create for us is it legally valid? I'm sure you have seen in your experience, you've seen all sorts of different types and formats of powers of attorney, and they are not all created equal. Is it legally valid and recordable? Who is the person that has the authority? Powers granted, are they specific enough to cover real estate? Some of these, online forms, off-the-shelf powers of attorney form are too vague. I give Marla Korkus full power and authority for all of my affairs. That's not going to cut it. We won't take that. It has to specifically say real estate. I grant the power, the authority for my real estate to be sold. If it's a buyer's power of attorney, to be purchased, to be encumbered or financed. One of the other issues we see is Pennsylvania has what's called Act 95, which is very specific about how a power of attorney can be, how it's executed, witnessed, and notarized. It requires both the agent and the principal to sign. It requires 2 witnesses, not 1. It requires two different notaries. It can be the same notary, but there's 2 signatures that need to be notarized. So it gets a little tricky. I've had clients that have gone into like a UPS store to do a power of attorney and can't, because there's not 2 witnesses separate from the notary, even in the store. So these are things we've got. We don't want to be having to get a power of attorney signed quickly. Some of the considerations that we have to consider is is the grantor incapacitated? So I had a situation once where I was told that the seller is incapacitated, they're in a memory care facility, and they cannot sign on their own behalf. Which is, that happens, that's okay. But the power of attorney that they presented to me was signed 2 days before we were having this conversation. So if this person is not able to sign, were they coherent 2 days ago? You know, these are the things that we as title agents are going to be concerned about.
So what do you do in that circumstance?
Well, in that circumstance, I would want to go, and we're going to get to that, but I'd want to go to the nursing home. I want to see this person. I want to see if they can sign for themselves.
And then if they can't?
If they can't, then we've got an issue, especially to my example, if it was signed, 2 days, because were they lucid 2 days before?
You could, if it comes down to it, the power of attorney is not valid and it doesn't cover incapacitation or doesn't survive incapacitation, the end result is someone has to petition the orphans court to,
Which is what we don't want to get into.
Right, so someone says, hey, mom's, in a home, she's incapacitated. Now, we have to sell the house for whatever reason. We need, she can't sign, so we haven't had a power of attorney. We need to get one, but, she can't sign it or doesn't know how to sign it, and we know it's not valid, so what do we do?
Unfortunately, it would be too late at that point to that example for a power of attorney.
Right. So
She would have to be officially declared incapacitated, and a court-appointed guardian would have to be,
Right.
and that, again, that's a whole nother slide. But these are the questions when we're presented with a power of attorney that why we're concerned about it.
Right, because I work in the aging population. And so,
Get your powers of attorney early. Sign before you're incapacitated.
I'm getting my own done as we speak, but so I guess you would say like, hey, if this was signed a couple of days ago, you'd want to go verify it, and if you determine like, hey, this
And look,
person,
as title agents, as notaries, we go to hospitals, we go to rehab facilities, we go to nursing homes.
I was at a recovery house once.
I was going to say, didn't you go to a prison?
I think just a
Somebody
recovery house is as bad as it got.
So that is our preference. We will go to, and a lot of these nursing homes, hospitals, they have notaries for this purpose.
right, and then you'll be able to determine like, hey, the person says, no, I was
Absolutely.
appointing my daughter, and this is we want to sell the house, and she's
And another note on powers of attorney too, from a buyer's perspective, a lot of times, if a closing gets rescheduled or the time that they want, somebody works a second shift or works the night, whatever the case may be, they can't get off of work. Oh, we'll just use a power of attorney. Lenders have gotten just as squirrely as title people about powers of attorney. So if you know in advance that your buyer might have an issue making the closing and a power of attorney is going to be needed, let's start having that conversation. You as the buyer's agent, me, and the lender as soon as possible, because most lenders will want what's called a specific power of attorney, one drafted for that transaction, not a general power of attorney that they may already have. So that's going to need to be drafted, approved by lender, signed, and then sent again to the lender for final approval before it can be used.
so
I'm going to begin a listing. I saw the will, okay, but so the wife has dementia. She can't sign anything. The husband is the POA for her. But now I'm hearing what you're saying. It's not as specific. It's like just a general. So who becomes the POA authorized to sign for her when we go to list it?
Well, it would depend how that power of attorney is written and when, hopefully she signed it before she was incapacitated, and hopefully the language in the power of attorney states that it survives her incapacity.
Okay, but that's not a real estate, just a general POA.
It doesn't address real estate
no.
at all?
No.
Yeah, that's probably not going to be usable.
So what happens? They should be seeing an attorney? I mean, how do you fix that then?
A guardianship.
I would say, my advice on that would be to speak to an elder care an attorney who specializes in elder care
And
for
bring
some
the power
guidance.
of attorney with you, just so the attorney can review it to double check that maybe it is hidden somewhere in the power of attorney. And also, if you're using a power of attorney, especially as a seller, the original power of attorney has to be given
thank you.
to the title company. We can't accept a copy. I mean, we can accept a copy to start, to review, but when we record the deed has certain language that indicates that a power of attorney is being used and is being recorded with the deed. A recorder of deeds does not accept copies of any document. They only accept original documents with a wet ink signature or maybe a properly notarized remote online notarization. We really haven't seen too many of them yet.
So, locating the original power of attorney is also something that let's start having that conversation early so that we know who has it and that it's going to be able to be presented for closing.
You get that back to me.
You do.
Yes.
It gets recorded. But once it's recorded, that's just as good as having an original power of attorney. But we always do overnight the original powers of attorney back to the agent for the principal or your seller.
Right. So somebody signs a power of attorney while they're capable, but that power of attorney is too general, doesn't specify real estate. Now they want to sell. That person obviously can't sign a new power of attorney because they're not. So you're saying you have to go to a lawyer.
Or do a deed package. If they're still of sound mind, the next best thing is to just sign the title documents themselves.
But they're incapacitated in your
Oh, they
example,
are.
which was the,
Yeah, that's what I'm saying. Because otherwise, wouldn't you just say, "We'll just write a new power of attorney that's real estate specific," and have
if they're competent enough to sign, if they're competent to sign a new power of attorney, that is a good
Yeah.
solution. If they're not, that's when it's gonna get a little trickier, and you would, in my opinion, you would want to engage an elder care attorney to maybe petition the court and get into a guardianship, which is.
Thanks.
So get those powers of attorney early. Sign them when you're competent.
And know where the original
And know
is.
where the original is.
All right, so wire fraud, we have 2 slides for this. I'm going to handle the first slide. Dana's going to do the second.
Again, we could do a whole thing on this, so we'll try to get through it.
Wire fraud is a very real and serious problem in our industry. Just looking at the slide, this is from the FBI. They only had 2024 statistics, not 2025 yet, but down at the bottom you can see that over $16 billion was lost to cybercrime in 2024 alone. Business email compromise is the #1 vehicle for real estate fraud, and the average loss per victim often exceeds over $70,000, which is usually your buyer's down payment. So in 2026, we as title agents are not just helping insure homes, we are defending your client's bank accounts. Just a few weeks, a realtor client of mine was sitting at a settlement for her listing, and after they signed all the paperwork, they realized that the buyer had wired $160,000 to a scammer. And now we're about a month later, and the buyer still hasn't heard back from the FBI, and the money has not recovered, and the listing is actually back on the market, and that buyer lost his life savings. It's a very real and present problem, and we're going to review how a business email compromise and the anatomy of a phishing attack happens and how the scam works. The first step in all of this is the actual breach, and I hate to say it, but it's usually the real estate agent's email that was compromised. At the title industry level, we are held to a very high standard, and we can't even get an insurance policy or an errors and omission policy without having certain levels of security in our with our software and our email. And it usually happens by clicking the wrong link. You should never just be clicking links. You shouldn't be opening random PDFs. So scammers don't just guess about their victims. They usually are squatting in a real estate agent or realtor's inbox, watching the transaction play out, and they are learning the lingo and the timing of a transaction. Once they see that the closing was scheduled is when they strike. They end up creating a spoof email, usually acting as the title insurance agent. They'll download our picture, our email signatures, and then just have an email address that might look very similar to the email that you're used to working with, but maybe a letter or a digit off. And then they either, just last week for one of my buyers, the scammer emailed the lender who was a lender that the buyer chose. So this scammer emailed the lender and the buyer's agent and said, hey, can you send me the buyer's email and phone number? And the lender just handed it over on a silver platter. And with the language, and she noticed, the realtor noticed the email address wasn't my typical email address. She screenshotted it to me and was like, hey, is this you? I quickly confirmed. So we were able to alert the buyers and let them know that you will be contacted by a scammer and you should ignore all correspondence. And at that point, they started ignoring me because they just didn't know. So the scammers usually send an email to the buyer sending revised wiring instructions, sometimes citing that there was an error on the previously issued version or the account was updated. They often create a sense of urgency, saying that it needs to be done immediately, send it by 2, or we have to postpone or cancel the deal. And you'll often see them say, don't call our office, our phones are down right now, just respond back by email. This usually happens late on Thursdays or Fridays. We're heading into a holiday weekend, which once the funds are in the scammer's account, that gives the scammer enough time to put the money into crypto or offshore accounts. So it's important to stress to your clients that they should be suspicious of all emails requesting funds to be wired.
Okay, so what can you do as agents? I love this. Marla coined this, so I am not going to take any credit. She calls it the multi-touch prevention strategy. So I know a lot of brokerages and a lot of agents are having some kind of wire fraud disclosure as part of their transaction documents, which is great. You should definitely have that, but you cannot rely on that to be your only communication with the buyer about wire fraud. Buyers are overwhelmed during transactions, so reminders must happen multiple times and throughout the process. Basically, I want you to be sick of the sound of your own voice, like I am of mine, when it comes to wire fraud. Every opportunity you get, please remind your buyers to be very cautious when discussing wires and actually wiring, because you want to make sure that they are dealing with the title agent and not a scammer. And it's very difficult to tell, especially for somebody who doesn't do this for a living. When should you remind buyers? You should remind them at your buyer consultation, when an offer is accepted, when you're introducing your title agent, when the deposit is due, because a lot of deposits we're seeing are wired now, a week before closing and a day before closing. Something else that we suggest is the main target for wire fraud is buyer's funds to close. So assumably you are using your title agent that you have a really good relationship with because you've referred the buyer to them. Know what their policy is. Know what their procedures look like. In our agency, we do not ever text wire instructions or any information about wiring, ever. And people who work with us know that. So if a buyer says, hey, I got a text about a wire, you know that is pencils down, cease communication, and pick up the phone. Now, there are some title companies that may text wiring instructions. Know what your title agency's process and procedure looks like so that if your buyer says, hey, is this, especially now because you've made them aware of this, hopefully they're checking with you every step of the way regarding a wire, you'll know if something sounds fishy or not, or if it's legitimate. Another thing to remember, and I think I can speak for any title agency, we do not change our wiring instructions, ever. If for any reason we change bank accounts, and we do, we start with new files. We are not changing our wiring instructions mid-transaction, ever, ever. No title company is changing their wiring instructions mid-transaction. So if your buyer should, hey, I got something that there's a change, phones down, pencils down, pick up the phone, call your title agent, call your broker, call your buyer, and know that something is not right. Stress to your buyers, the phone. People hate the phone. And I know especially our Gen Z buyers do not want to talk on the phone. I know. They don't want to talk to me either. But fraudsters are not using the phone. So that's why we need to use the phone. They, it's AI, they're overseas. And just know these scammers, these are not pimply faced kids sitting in the basement of their parents' house trying to scam money. These are sophisticated international crime syndicates. Look at that was the previous slide, $16 billion. These are very sophisticated crime networks. And a lot of them are overseas, so they definitely don't want to talk to you on the phone. So stress to your buyer, hey, this is our title person. Anything regarding a wire, this is the number that you are going to call. Because sometimes when a scammer gets into an email conversation, they're giving you a different number that's not mine or the title agent's. So encourage them to verbally confirm any wire instructions every time, even if they do multiple closings. I had a situation where I did a closing for a couple. They were new to real estate investing, and they did 2 closings in a month. First one went off without a hitch. The second one, again, a lender provided information that they shouldn't have, and a scammer gets involved in our conversation. They wired to a completely different bank account that second time, and it wasn't mine. So they had even just weeks before emailed, but were told that they changed and wired to a fraudster. So encourage verbal confirmation every single time, even if it's somebody we've worked with before.
And also for your sellers, you'll find, I think, that most title agencies are using secure portals to obtain your seller's wiring information. There's certain platforms out there that when a seller manually or logs into their bank account through the secure platform and uploads their wiring instructions, along with uploading their driver's license and scanning their face by looking front, left, and right, these platforms ensure the wire transaction. So it's a safeguard for us. And you should be receptive to any title company that is trying to make sure that your client's money is safe and arrives where it needs to go. And if you have an elderly client in their 70s, 80s, or even 90s, and they want to wire, and the title company is requesting to receive their wire information by a secure portal, then maybe it just means that you're going to have to hop in your car and drive over to your client's house to guide them through the process. You just have to remember at the end of the day, it's to protect your client and their money.
So, how do you protect yourself where, I could see a lot of people going, well, hey, I didn't, you should have told me that. You should have known. My agent told me, but, I just lost hundreds of thousands of dollars.
You protect yourself by reminding them over and over and over not to trust anyone.
Right? Hey.
This secure portal is how we protect ourselves.
Yeah, that's kind of our
main.
main.
Once it happens, it's hey, you should have protected me.
Well, let me tell you,
right?
when money goes missing like that, it is a you.
Right.
So what I always think about is, how am I going to answer those questions on a witness stand or in a deposition?
Right.
Did I do everything? Part of the secure portal that we use in our operation, the buyer clicks a little disclaimer that basically they have to read, and it says, I understand that these are the only wiring instructions I will use, to hopefully stress that it is important. So, you don't want to be in a situation where, well, I told them once. Be able to say, I reminded you at this stage, at this step, you signed the form, I sent you that email. You know, you want to be able to not only be able to say it, but know that you did everything you could to make them aware.
I mean, have you found clients that have lost money coming back to you, litigate against you for,
It
you know,
has never happened to me,
No.
unfortunately. I go to great lengths to make sure that my buyers are aware of the wire fraud and the very real problem it is in our industry. I send multiple pieces of correspondence throughout the transaction, and after my listing agent had her listing did not close because the buyer wired that $160K somewhere else, that's when we implemented
Another touch point.
Which is 2 weeks before closing, I reach back out with just one email reminding them about the wire fraud. Is it going to be okay if we go over 12:30?
Yes.
Okay. All right.
So with deed signing remotely, what's your policy for getting those proceeds to the seller?
For me, my personal policy is that I do not care how old the seller is. If they want a wire, they need to log into the closing lock. The portal's called Closing Lock. They have to log into the secure portal, enter their wiring instructions, scan their face, scan their ID, and then they can get a wire. If they do not want to do that, then we cannot offer the accommodation of a wire. We can overnight a check.
Overnight check.
And we can also accept in some cases a signed notarized form, but it's in person, and that's part of their deed package. So we have their photo ID, we have the notary's information, and then even that, we have a secondary follow-up call to verify those information using the number that we have on file for that seller, and we won't send out a wire without that second verification. So it's a real problem, and it unfortunately is getting worse, not better. So, you know, be aware of it and cover yourselves, cover your buyers by talking about it early and often.
All right, moving on to the next slide, child support. Past due child support is usually one of the items that surprises a buyer or seller, and it's the most uncomfortable to talk about with your client. Most people don't associate child support with real estate, but from a title perspective, it is something that we are legally required to pay. In Pennsylvania, unpaid child support automatically becomes a lien by operation of law, and that lien attaches to any real estate owned by the obliger or the person who owns the child support. Some sellers seem surprised once the title company says, hey, we found past due child support. Child support liens don't usually appear on credit reports. A lot of people might believe that they're current on their child support, or they're close enough, or maybe they even have some sort of handshake deal with the person that is receiving the child support. But child support liens are not something that can be negotiated until the domestic relations office confirms that there's zero balance, or they issue a payoff statement. That lien is active and has to be addressed. In the rare instances where a buyer might have past due child support, if it's a cash buyer, we don't necessarily have to pay it, but we have to add it as an exception to their title insurance policy. But if they're financing, the lender most likely is going to want to have that past due child support paid. This is why we reach out and ask for your client's social security number. Child support searches are tied to social security numbers, not just names. If we have to search for child support without a social security number, sometimes we cannot complete the search.
Actually, I don't even think you can search it
Anymore,
that way.
yeah.
Bankruptcies you still can, but you can't even get a search without a social.
So it's important when the title company asks for your client's social security number, it's important to get it at the start of the transaction. That's not something that you want to send, or your conveyancer sends over when they're sending like the final water sewer cert, because It takes time if a hit is found on Social Security, or I'm sorry, on the domestic relations website. We have to then reach out to the county domestic relations office to order a payoff letter, and that's not something that can be done quickly. Sometimes the turnaround time is a few days. So your takeaway is that child support follows the person. It does affect the real estate being sold, and when you are asked for the Social Security number, please have your client call the title office with that information. When it's addressed early, it's manageable, but if it's discovered late, it becomes a last-minute crisis.
All right, judgments and liens. One of the simplest questions you can ask, especially if it's a somewhat distressed sale, maybe a divorce, is, are you aware of any outstanding judgments, liens, unpaid HOA, anything that we're going to need to know about to get ahead of? Nothing can really derail a closing, like a bunch of credit card judgments that nobody knew about or weren't disclosed. Old business debts, credit cards, medical bills, unpaid taxes. Typically, when there's a lender involved, they're paying taxes, but they're not paying HOA liens. We've got child support, which Marla just covered. There's, business loans, confessions of judgments. Maybe there was a business that the seller had that went bust, and there was some things they signed for personally. These are all going to show up on a title search and need to be addressed. So, one of the things that we're stressing here is that early disclosure matters. And I know it's uncomfortable to ask these questions. I mean, I do recognize that. But think about how much more uncomfortable it is for us when we've never even met your client, when we're asking. So if you can, as you're building a rapport, especially with your sellers, are there any mortgages, judgments, liens, home equity lines of credit? That's another thing we see a lot of is, people don't realize that home equity loan is actually a lien on title, and a payoff has to be ordered. It's not a personal loan. It's secured against the property. So, we want to ask questions early so we can get prepared. A lot of time, and look, it's not like people are trying to be sneaky or deceptive. A lot of times they just don't know, especially a distressed seller, they're not really staying on top of things. So
How would they know? I mean, like, if they're like, 20 years ago, 10 years ago, I had a contractor, we debated over something, and then, how would they know there's a lien on their house?
Well, look, if it's something that was 10 years ago, it may be something that's now out of time and expired. So, but I mean, we're talking about like recent stuff, credit cards that are unpaid. You're getting the lenders from the creditor, now maybe from an attorney.
Is there a statute of limitations?
There is.
Depends on the type of judgment.
Depending on the type of lien, there is anywhere from 5 to forever,
I think
depending.
Going back to your question earlier or statement when you said you had a property, everything was fine, but judgments came up on another property, Pennsylvania does have a law that if you own multiple properties in one county and you have not been paying taxes on one of those properties and those taxes are liened, it does not matter if you are selling a different property, as long as there's a lien on real estate that you own under the same name, that does have to be paid.
So I learned through that experience that you chase the name, not the property. This guy owns like 5 or 6 properties. Liens on these, the one we're selling, was clear. He said, "Paul, no issue, blah, blah, blah." And then he had to pay him, or they were going to hold escrow.
Yeah, I think your example was Philadelphia, wasn't it? My memory. Yeah. So there, I think it's CE, code enforcement. Code enforcement judgments are considered in persona against the person, not against the property.
It's water.
I believe water liens are CE, code enforcement. So, I mean, municipalities and the state are getting more aggressive, and they want to get this money no matter what you're selling. So they've started interpreting very liberally some of the statutes they have on the books,
Or creating new laws to address it.
or
so
just
they
creating new
can
ones. So again, the takeaway here for judge is just ask, especially if it's a distressed sale. And another reason you want to ask, especially if we're talking about certain types of judgments, like credit card judgments that can be negotiated. If we're finding out about these last minute and scrambling to get them, there's no time to negotiate. A lot of times you can negotiate lesser amounts for certain
Company
judgments.
put a lien on your home?
They put a lien against you.
You judgment.
Yeah, they file a judgment against you, which then attaches to anything that you own in that name. So,
Even if it's a joint, if you're, like, if it's my credit card in my name, but the house is in.
that would not, there are certain instances where if there's joint ownership and the judgment is just in one name.
Joint ownership when it's a husband and wife. Tenants managed
Yes,
property.
excuse me, thank you. Marital property does offer some protection from judgments and creditors. So, all right.
All right, so HELOCs and mortgages. Another important, often overlooked question that you can ask your seller is, have you taken out a new mortgage or home equity line of credit recently? Now more than ever, homeowners are tapping into their equity, getting HELOCs or even refinancing to be able to put larger down payments on the next house, bridge or swing loans, or even to compete with cash offers and purchase their next property outright. So we're seeing more recent mortgages pop up on our title commitments. Any mortgage or HELOC, new or old, creates a lien on the property. Sometimes sellers are under the impression that they haven't used their line of credit in a while, or it's at zero, so it doesn't matter. Even if there's a zero balance, there is still a lien at the county courthouse that needs to be addressed. And with these bridge and swing loans and the recent lines of credit, they're happening so close to properties being listed where when a title search is ordered, that new line of credit or mortgage might not have even shown up at the courthouse yet, so it can get missed. But what a lot of realtors or agents don't understand is that we don't just do one title search. When it's a day or two prior to the closing, we do a second title search to see if anything new has popped up since we did the search a few weeks ago. And that's not the point in time where you want us to alert you that a new mortgage was put on record. Most mortgage payoffs, especially lines of credit, can take 4 to 5 business days to arrive. And so now you're stuck with making a decision. Do we have to delay the closing until the payoff arrives, or do we have to hold escrow to make sure that the title company has enough funds? And going back to someone's question, when we have to hold an escrow for an issue on title, it's usually 1.5 times the issue. So if you have a $200,000 line of credit, we have to escrow 1.5 times until that payoff arrives. And if your seller was counting on using all of their proceeds to buy a house the same day or the next day, that becomes problematic. Another point that I want to highlight, and I've seen this happen several times, just in 2026, if your seller comes to you and says, I think I'm just going to pay my mortgage off early to make it easier, that only makes things difficult. You should encourage them to not do that until they talk to the title company first. Paying off a mortgage does not automatically clear the lien from the property. Most mortgage lenders take 30, but more typically 60 to 90 days to file the paperwork at the courthouse that removes the lien from the property. The paid in full letter that your sellers receive after a mortgage is paid in full generally contains no information that a title agent can tie back to the original mortgage, because lenders sell their loans loan numbers change when that happens. And no mortgage payoff letter usually references the original mortgage amount or even the book and page, which would allow us to connect all of the dots. A paid in full letter is not sufficient. And so instead of a clean payoff at closing, we're waiting on paperwork for a loan that was paid in full. And you don't want to have that late discovery because you're either delaying a closing, which has multiple repercussions with maybe the buyer having to extend their rate lock or not having enough funds because the seller has to escrow. And that leads to last minute scrambling and frustrated clients. So you just want to make sure you are asking your clients when you're taking the listing or really like when you're going on the market, have you, since owning the home, have you taken out any mortgages or opened up any lines of credit, even if you haven't used them? And always just loop your title company in if your seller has a question that might impact the timing of the closing.
I think since timing is getting a little tight, we'll just kind of wrap up.
Okay.
Even though I love talking about bankruptcy, it's so fun because I know everybody has other places to be. But I just wanted to first thank you everybody for coming. Sorry, went a little long. We had a lot more questions than I originally planned for. But hopefully Lauren will have us back and maybe we can get to some of the slides that we didn't get to. But I think the main takeaway here is communication. A lot of it often early and with your title team.
And make sure you're reading your title commitments.
I know, I really did like that slide too, but we'll do. Yeah, definitely read your title commitments. I know that's a big ask, but there's really a plethora of information on there that it's going to show you. It's going to give you, not only the names and the address and the sales price, which obviously are important, but it's also on Schedule B going to give you kind of what I like to call your honey-do list, all the things that we need. So it's kind of your roadmap to get to closing. And then Schedule B2 is your exceptions.
Also something I think I've heard in the past that when you get the listing, if it's owned by an LLC or whatever, you should get those documents also for title up front, right? Not wait.
Yeah, so there's a QR code on the screen. If the viewers online are on your phones and you can't scan the QR code, you can go to marlakorkus.com. I have a resource tab that if you weren't diligently taking notes, all of this is all compiled into guides and checklists that you can run through with your client when you're meeting with them. What
tab is that under again?
So if you go, I think it says resources or resources and guides maybe. But there's seller questionnaires, there's guides on explaining inheritance taxes. There's a list of if you are working with a trust or an estate or even LLCs or corporations. I've compiled a list of what documents you should be asking for from those clients. But you can always, I love being a resource to realtors, even if we don't work together. I'm happy to chat through scenarios with you. So if you have any questions, even after reviewing the website, just give me a call, shoot me an email. I'm married to a realtor. I know that real estate is not 9 to 5, and you can catch me at any point of the day, Sunday through Saturday.